Okay. 4-1, 4-2, 4-1, and 4. Patel versus Macy, Inc. Okay. All right. I'll give you 5. People versus LaShawn Martin. Okay. All right. Let's do 6 and 2 and 6. Cedar Grove versus Ehrlich is submitted. Rodriguez versus Triborough Certified is submitted. B. King Chick versus Organization for Defense is submitted. First case on the calendar, People versus Joseph Griffin. You may proceed.
May it please the court, my name is Nahara Chowdhury with the law firm Simpson, Thatcher, and Bartlett for the defendant appellant Joseph Griffin. In the throes of a psychotic break caused by untreated schizophrenia, Mr. Griffin hit an individual once in the head with a long metal object because he believed that person had stolen his backpack containing his identification. 90 minutes later, Mr. Griffin threw himself onto the windshield of a moving taxicab in an effort to kill himself. For individuals like Mr. Griffin,
Is the evidence equivocal about whether he was trying to commit suicide?
it is clear from the record, Your Honor, that he intended to hurt himself, as reported to a police officer after the incident. For mentally ill individuals like Mr. Griffin, incarceration and supervision produces more harm than benefits. We thus respectfully request that the court reduce Mr. Griffin's sentence in the interest of justice to 8 years in prison, followed by 3 years of post-release supervision.
The violence was anomalous behavior for him. Is that
Extremely
correct?
out of character. He had never previously been convicted of any violent offense, never used any weapon, had no pending charges at the time. And it's pretty remarkable because he had been living on the streets for years and suffered serious psychiatric issues for years. This is a kind and gentle soul who had a horrible breakdown.
Now, counsel, this information that you are providing to the court at this point was before the plea court and the sentencing court at the time that the plea and the sentencing was imposed.
Yes, you're correct. It was before the sentencing court, but the legislature has vested this court with broad plenary power to re-examine the case in its entirety and determine whether the sentence is unduly harsh or severe in the interest of justice.
And
Also, someone died and your client got 12 years, correct?
Someone did die. This was one hit in the throes of a psychotic breakdown. This individual actually, after he was hit by our client, he actually got up, walked down the street. I don't think our client at the time had any understanding of what had happened. In fact, it wasn't until he received treatment at Rikers that he even comprehended the gravity of what had happened. And once he understood what had happened that day, he expressed.
The hit was so hard that he fractured this man's skull and there was a decompression in his skull as a result of the strike from your client. And his mental illness is not lost on me, I want you to know. But tell me, what is it about his past that should fill this court with any kind of comfort that should we reduce in the interest of justice, that when he gets out, he is going to be on top of his medication regimen? Because
That's a very
he was on the street, not receiving medical treatment, at some point had to know based on his history that he had a problem, right? And I get it. When you're decompensating, it's hard for you to assess that you're decompensating. But we have to concern ourselves with society and the safety of society. So what is it that can give us the kind of comfort, for lack of a better word? But I think you know what I'm saying.
That's an excellent question, and one in which I made sure to familiarize myself with. And what I will tell you is that he has been in the care of the Department of Corrections since 2017. He has been under the care of the Office of Mental Health, which is obligated to care for him and provide him with medications. And shortly after he was incarcerated, he was diagnosed with schizophrenia. He was prescribed Risperdal and Prozac, in addition to Benadryl for use as
Had he been diagnosed prior?
he had been diagnosed at age 16,
Okay.
while he was on the streets. But at this point now, he has had over 7 years of continuous care under the auspices of the Office of Mental Health. And the Office of Mental Health is legally responsible for coming up with a comprehensive discharge plan that would include mental health treatment upon his release. So this is really this is probably the longest period of his life where he has received continuous mental health treatment.
Okay, all right. You'll have time on rebuttal. Thank you. You may proceed.
Good afternoon, Your Honors. May it please the Court. Nathan Morganti on behalf of the people.
Counsel, why shouldn't we exercise our interest of justice powers and reduce the sentence?
Well, Your Honor, I think that the main question that answers that is that the only question here is, was the sentence appropriate, a 12-year sentence, for defendant violently striking someone over the head with a long metal object, killing them? And the sentence the defendant received was appropriate. It was appropriate because everything was taken into account by the judge below. And the judge below said, he really answered that question, really emphasized that when he said that this case was tragic, but that the real tragedy here was that someone had been killed. And that showed that this sentence didn't lose sight of the fact the defendant violently hit someone over the head with a metal object, killing them. And for killing an innocent bystander, defendant faced a maximum of 25 years in prison. And his plea deal eliminated over
That's assuming a conviction after trial where a defense of insanity would have been appropriate, or mental defect certainly would have been a viable defense here. The man threw himself on top of a car, right? So you know, had he gone to trial and been found mentally unfit, he'd be in a mental institution until such time as he was no longer mentally fit, so.
Well, Your Honor, there's two responses to that. The first is that defendant was examined by 2 psychologists, and the reports were in front of the sentencing judge. Both of them did find that he was fit to proceed to trial.
Fit to proceed to trial at the time that you're examined is different than I was in the midst of a psychosis at the time of the event. And that, even if you are fit to stand trial, the issue for the jury would not be whether you're fit today. The issue is were you fit the day you committed the crime, right?
That is correct, Your Honor.
So the fact that he was found fit to proceed to trial, which by the way is probably the lowest standard known to man on mental health issues, right? That tells us nothing. The issue is, should we send a man who we can see from the record was in all likelihood in the middle of a psychotic break? So not in charge of his mens rea.
Well, Your Honor, there was no question that defendant was not experiencing the type of delusions that this court has found in the past to warrant this extraordinary circumstance. Defendant's delusions were that someone had stolen his backpack and that his identity would be stolen. That then led him to hit someone over the head, which is not the level that we've seen in other cases, the cases that defendant cites that this court has found warranting a reduction in sentence. And I would also just like to point out very briefly that the record is a little equivocal whether or not defendant did throw himself in front of this car. In fact, both the People's Omnibus motion at page 2 and the complaint both indicate that the cab had actually either slowed down or stopped and defendant jumped on top of the car. So that record is equivocal, going to Your Honor's point earlier.
Counsel, did the sentencing court take his history into account, that he was removed from his mother in foster care, that he was homeless since the age of 16?
Your Honor, I am not sure if that information was in front of the sentencing court other than what was in the PSR report, but obviously it's the people's position that everything in the PSR report was taken into account, as well as the 2 lengthy psychological evaluations that did touch on these issues. So yes, in general, those issues were taken into account.
Oh, that was one of the reasons why the court offered the 12 years instead of the 17 that the people were offering.
That is correct, Your Honor. It was over the people's objection that defendant only received 12 years, and that's an important point. That shows that the sentencing court was taking these issues into account when it did reject the people's offer of 17 years and say, no, I'm only going to give defendant 12 years here. And everything the defendant is now claiming appeal was in front of the sentencing court. And that is why this court does not need to exercise its power to reduce a sentence in the interest of justice. If Your Honors have no further questions, we ask that you affirm the conviction. Judgment.
Thank you.
Thank you.
You have a minute.
I'll keep this very brief since I only have 1 minute. I will say two things. First, the statutory minimum for this offense, which was the top count in the indictment to which he pled guilty, was 5 years. Mr. Griffin received 12 years in prison. And when we're considering prison terms, we need to think about what's the minimum amount of incarceration that is necessary to achieve the goals of public safety, punishment, and rehabilitation, and we respectfully submit that 8 years is more than sufficient in this case. And with respect to precedent from this court, we would like to underscore that People v. Reyes is the exactly perfect case to look to there. The defendant suffered from schizophrenia, suffered a psychotic break during which he experienced auditory hallucinations, commanding him to stab someone. In this case, counsel is right that there is no contemporaneous evidence of auditory hallucinations at the time of the incident. That just isn't reported in the record. But even in 2018, when he had his competency examination, he reported that he was taking medications in order to deal with the auditory hallucinations that he.
Also, isn't he getting out?
I'm sorry?
Isn't he getting out soon? Isn't he almost done with 2/3 of the 12?
He has several years left to go, and in prison has been a very harsh environment for him at this point. You know, he has reported to us that he's feeling very isolated, very misunderstood in prison, as one might expect from someone suffering from serious mental illness in that kind of an environment. So we respectfully submit that no further good is going to come for him or for society from further incarcerating him.
Isn't Reyes attempted murder as opposed to an actual death that we have in this case?
It was attempted murder, right? He actually stabbed an individual. In this case, it's manslaughter in the first degree. He hit an individual with a thing he happened to probably find on the ground. This wasn't a stabbing. This was a sort of a aberrational, out-of-his-mind act that occurred.
It was still a savage act.
It was
Somebody
no
died.
question, it was a horrific offense, and you know, it's a tragedy that unfolded as the trial court observed. It was a real tragedy on all fronts.
Thank you. I want
for
to
your
also
consideration.
thank you, and please thank your firm for lending you out for this case and serving in a pro bono capacity. And of course, the people, thank you as well.
Thank you very
Have a
much.
good day. Rasso versus Avon Products. Huh? Yeah. Justice Mendez is recused from this case. Should there be a tie, the court will follow the Appellate Division First Department rules with respect to vouching in another judge. All right, you may proceed.
May it please the court, my name is Mohammed Haq on behalf of the defendant appellant Colgate-Palmolive Company. This appeal results from the denial of Colgate's summary judgment motion on causation under New York law and Texas law. Under New York law, it's simple. This case is identical to Nemeth. The facts, the experts, their opinions, the underlying basis for those opinions are the same. So much so that when plaintiffs submitted their opposition to the summary judgment motion before the reversal came down from the Court of Appeals on Nemeth, they admitted at least 8 times that the evidence that they're putting forth through Dr. Moline in this
Counsel, you recite those in your brief very completely, I think. So let's talk about choice of law, because you choose Texas.
correct.
Now, how do punitive damages, the difference in punitive damages between the two jurisdictions go into that calculus?
Because under Texas law, punitive damages provides a cap. New York law does not have any such cap.
Right, but are punitive damages directed toward compensation to the victim or the plaintiff, or are they directed toward the behavior of the defendant?
It's an analysis of both. It's an analysis of both, and when you're analyzing these claims, it's
The reason I ask that is because Colgate is obviously headquartered in New York City, or
Correct.
New York State, anyway.
correct.
So-
Its principal place of business is here in New York. But when analyzing these claims, whether it's causation or punitive damages, the plaintiff and Colgate agrees that's it's conduct regulating. And when you're doing a choice of law analysis as to conduct regulating as opposed to loss allocation, what we look at is the locus of the tort. And the court identifies the locus of the tort as the place of the last event. Now, when you're doing a loss allocation, which plaintiff agrees does not apply here, that's when the party domiciles matter. Now, when we look at the last event in this case, no matter how we look at and how this court chooses to define what that last event is, it points to Texas. Because the plaintiff here was a lifelong resident of Texas. She last used Cashmere Bouquet, Colgate's product, in Texas. She manifested her symptoms in Texas. She was diagnosed and she was treated, and she sadly passed away in Texas. All of these events, if we look at it and we characterize them as last events in any which way, it points to Texas. And so under this court's and New York's choice of law analysis, Texas has a superseding interest. And if the court below applied that standard correctly, then Texas law would have applied, and under Texas law, where causation requires a showing of a doubling of the risk at a minimum through epidemiological evidence, it would have been clear that Colgate met its burden while plaintiff failed to raise an issue of fact because there is no such epidemiological evidence showing a doubling of the risk. In fact, all of the epidemiological studies that Colgate submits with its papers demonstrate—
But Texas doesn't require epidemiological studies, though, correct? To show causation. I mean, it's preferable, but there are a number of reasons it's hard to get that in asbestos cases. So,
well, the way the court reads in Havner and Bostic, which is a Texas Supreme Court decisions, they require epidemiological studies at a minimum. It's the floor, and not contrary to what plaintiff represents, it's not the ceiling. You have to have an epidemiological study along with other studies that demonstrate more than just an association. You have to demonstrate causation. And as a result, if this court applies Texas law—
specific causation you're talking about here.
Correct.
Yeah.
And if this court applies Texas law, then it's clear that plaintiff does not meet their burden. They don't raise a tribal issue of fact. Dismissal is clear under Texas law. I just want to briefly turn to the issue of Nemeth, if this court allows. Dr. Moline's evidence here on Nemeth, on this case, is identical to Nemeth. She, in fact, submits a very generalized conclusion with no foundation, where she goes no further.
In Supreme Court, even though Nemeth had come out, Supreme Court doesn't mention Nemeth, does it?
Correct.
Yeah.
It didn't mention Nemeth. It didn't even acknowledge plaintiff's concessions. But what we have here is the same exact type of evidence. And while here now they're saying that they offered something more, which is through the simulations of Dr. Compton and Dr. Longo, what they failed to mention is that those simulations were part of the record in Nemeth. They were also part of the record in Olson that was before this court. The Compton simulation was part of an article we refer to in the brief as the Gordon article. They agree with that. It's part of that article. Also part of that article was Sean Fitzgerald's simulation that was in Nemeth, the glove box test. And the Court of Appeals made clear that these simulations, while they try to cast themselves as breathability studies, they're not. They don't calculate inhalation levels. What's more is that they don't correlate any released fibers to a level known to cause peritoneal mesothelioma. The same issue exists with Longo simulation. That was before this court in Olson, and the same outcome happened there. What's necessarily missing here is any scientific or medical study that demonstrates what the minimum threshold is for to cause peritoneal mesothelioma. All of the studies that Dr. Moline relies on, what will go to that proposition, were rejected by Nemeth because they don't develop and they don't establish that correlation. So even under New York law, dismissal is warranted because this case provides the same sort of outlook that was in Nemeth and Olson. Thank you.
Thank you.
Good afternoon. May it please the court. Jim Kramer on behalf of plaintiff respondent. I think I'd like to start by, perhaps my term, undoing a bit of the conflation or possible misunderstanding of what the evidence is in this case and what was addressed by Supreme Court in its motion, in its order rather, denying a summary judgment here. I heard counsel represent to the court when he first stood up that this is identical to the Nemeth case. Nothing could be further from the truth.
What about all the repetitious statements by Dr. Moline below concerning that the proof is the same as offered in Nemeth? At the time, Nemeth was our decision in Nemeth, which was later reversed.
That is true. However, Justice Silvera's decision was decided after Nemeth 2 came out.
But he doesn't mention Nemeth, right?
He doesn't, he doesn't have to in a
mention the
sense,
Court of Appeals.
Justice Moulton, because Parker, which is the law of the state, governs both his decision as well as Nemeth. And I'd like to make some clear distinctions here as to why, even under Nemeth 2, the evidence as it exists in the record on summary judgment creates clear issues of fact. And here they are. Dr. Moline indeed does state that the asbestos exposure here from cashmere bouquet would cause peritoneal mesothelioma. One need look no further in the record than R6291, her 3101D, where we unequivocally state that she will represent at trial a scientific expression that the
But
levels
she's got to
here-
do that now in summary judgment. She has to lay bare her proof, correct?
That's true. However, Justice Moulton, there is no rule in New York stating that in a 3101D or in a report that all opinions necessarily must be stated with the exact specificity as they would at trial. They need only present notice to the other parties as to what those issues will come out through the evidence at trial. And this is key because she goes even one step further in the 3101D because she says she's going to relate back to the Gordon study, but more importantly and key for this court to understand and different from the evidence in the Nemeth trial, Dr. Compton will be testifying about the exact bathroom simulation that he performed. Forget about what was in the published study. He performed that study.
Was that in the record? before
Yes, it
the
is in
judge?
the record.
Okay.
In fact, we presented a...
And that goes to dosage and the amount of inhalation that the plaintiff...
That is precisely right, Justice Moulton. He talks about the use of a powder puff in a bathroom simulation, producing levels hundreds of times greater than the PEL under OSHA. Now, this is key because what...
Now, but isn't one of the problems with that study, as has been alluded to earlier, that while it tells us how many particles are in the room, it doesn't tell us how many of those particles actually
And this is the conflation.
gets breathed in by the person, right?
This is the conflation that it's so important for the court to understand because what Dr. Compton did in his study was an industrial hygiene study with filters to represent what would be breathed in. And he went a step further than the Fitzgerald Gloves box study. He actually measured the particulate and then measured the asbestos fibers. So there is no guesswork here. This is exactly what Justice Friedman said should have been done in his dissent in Nemeth 1. We have that proof here. Dr. Compton is going to be talking about a simulation study performed finding asbestos not in some random product, but in the very product who will be there at trial, Colgate-Palmolive's Cashmere Bouquet. That was the product that was studied.
Is there a place in the record that tells us, that one of your experts tells us specifically what level of exposure is necessary, or at what point does the exposure now mean you're going to end up with this illness, right?
Yes. So there is no such study that any medical expert on either side will ever be able to point to say
But
this
for
level.
instance, I mean, EPA will say any amount over X in the atmosphere is too much and is not recommended, right? Like,
Yes, and that's OSHA. Dr. Moline relies upon OSHA. Dr. Moline
so
relies
what is
upon
that?
MISHA.
Where is that number in the record? Is what I'm saying. So where can I find in the record that the industry says this number of fibers in the air can expose someone to a too high of a level of exposure for potential cancers later? right?
R5691, which is Dr. Moline's report from 2019. R6291, which is the 3101D from June of 2022, where Dr. Moline's testimony is further exemplified. And since you asked, Justice Manzanet, in Dr. Moline's report, she goes into significant detail about the exact levels of asbestos fibers released from Cashmere Bouquet and talks about how they relate to OSHA, Mattenclot, MISHA, other studies finding elevated levels. Now, importantly, this court's, and I understand my time is up.
While you have a question in front of you, you're okay.
Thank you, Your Honor. In McWilliams, in Sasson, two recent decisions rendered by this court where similar evidence has been propounded on both the summary judgment level and then again in post-trial. Dr. Moline's going to be talking about these same exact issues. An industrial hygiene study performed of a product demonstrating respirable fibers and then comparing them to the medical literature as enunciated in her 3101D, demonstrating that these numbers from the study are far and away above what the medical literature shows to be fourfold, eightfold, 12-fold, and more increases in sustaining this disease. There is no doubt that in this record, as Justice Silvera acknowledged, there are questions of fact as to specific causation. Even if he did not call out Nemeth by name, they are here. I would love to discuss choice of law. I know that I'm beyond my time. If your honors have any questions in that regard, I think that Padula, this court's decision in De Silva, clearly make certain that when you're looking at multiple cituses of the tort, especially where there's a domiciled New York defendant, as there is here, and injury as there is here, undisputed, as we demonstrated in our affidavit from Dr. Brody, who said that these genetic errors occur 48 hours after inhalation. And of course, our client was here roughly 800 days sustaining injury each time she breathed these fibers on each of those 800 days. If you look to this court's decision in De Silva, when the situs of the injury, even in multiple jurisdictions, occurs in New York, this court has said that New York law will apply.
What about your argument that if Texas says it has to double the risk, and you say that requirement is procedural, do you have any support for that?
Well, I think the support is in the fact that, first of all, if you look at what New York requires to establish a dispute, we have to look to see if there's any conflicts between the two laws. And under Havner, under Bostic, Texas is very clear that they have a substantial factor level of causation, just as New York does. Now, the issue of whether or not an expert at trial meets his or her evidentiary hurdles of showing what that means is just that, an evidentiary requirement that follows the procedural law of the forum state, which in this case is in New York. And I'll just note, because Justice Moulton, you led your discussion when Colgate was standing on questions about punitive damages. There's not a single case cited in their briefs discussing the analysis of punitive damages. I think when this court looks to the choice of law analysis of New York's actual interest here, when you're talking about a situation of governing the conduct of a company that, as we allege, did this reprehensible harm, New York has the better interest in governing how its own companies should act, in this case, in the punitive damages context, than Texas would.
Okay.
So in case there are any other questions, I'm happy to answer them. If not, I'll sit down.
Thank you.
I'll be brief.
Could you address whether Dr. Compton's studies are sufficient?
Dr. Compton's studies are not sufficient, and here's why. His study was part of that Gordon article that we referenced. That article was before the court. It was analyzed. Justice Friedman actually opines on that article in his dissent in Nemeth. And it's, again, represented in the dissent in the Court of Appeals in Nemeth. It's not like the Court of Appeals didn't look at what that article contained. The simulation that Dr. Compton includes here is exactly as it is in the Gordon article. So
Is the problem that it doesn't quantify the exposure through inhalation? Is that the problem with Compton?
That is the problem, and that's how the majority in the Court of Appeals represented it, is that not only does it not look
Well, how would that study ever, how could that ever be conducted, right? Because you can't expose someone who's healthy and see, let's see how long it takes before you get sick, right? So how do we assess how much has to be taken in?
I think the way to actually approach it is similar to what's been upheld in Sassone and McWilliams. What this court found was sufficient, where there was air cassettes utilized or proper sensors utilizing, and more importantly, the reports there characterize it as inhalation studies. When you read the Gordon article, it itself says it's a releasability test. So that's as far as it's going. It's not looking at the inhalation. What it says is they're inhalable sized particles. And the Court of Appeals looked at that language and they said, even if we accept that, what it doesn't show is the correlation. What is the threshold? And my adversary argues here that Dr. Moline is going to show, according to a 3101D disclosure, they have to lay bare their proof now. This is what the court held in Dyer, and that's why it's required. Summary judgment isn't about what can we show later on? We've established our prima facie case. They agreed with it. There's no dispute about it with the court below. They should have raised a tribal issue of fact by laying bare their proofs now. This court has no further questions.
Thank you.
Thank you so much.
De Los Santos versus Carlisle House. Please wait for my colleague to get back. There he goes. You may proceed.
Thank you. Good afternoon, and may it please the court. My name is Ross Wagner. I'm from the law firm of Coffey Modica. I'm here on behalf of the defendant appellant Carlisle House. The appellant respectfully requests that the order of Justice Suarez from March 2nd, 2023 be reversed and rescinded. Your Honors, there is a genuine dispute of material fact as to liability of the defendant appellant as to Labor Law Section 240 sub 1.
And how was that established?
Your Honors,
Who gives you an issue of fact?
here the framework put forward by this court and the Court of Appeals in
No, tell me specifically. In this case, what witness, what fact is in dispute?
the happening of the accident, Your Honors, the crux of
So there's no case law in this department that says there has to be a witness to a fall, right?
That's correct.
Okay, so tell me then how does, because essentially you are resting on, you shouldn't believe the plaintiff. So if you're gonna do that where you have no witnesses, right? No one contradicts what he says other than he has misidentified who was there on the day of his accident.
He didn't just misidentify who was there on the date of his accident, Your Honor. The plaintiff's sole...
He thought it was Peru.
Yes.
It wasn't Peru because Peru had already quit because he had fallen or gotten hurt on this site. So he wasn't available because he was already injured, right? So somebody else was working with this plaintiff on that day when he says he fell. So my question is, who creates the issue of fact? Because the fact that Peru is not there and tells us he wasn't the one, that to me isn't enough. So what else?
The person who creates the issue of fact here is Peru himself. The plaintiff testified in his...
All he can say is he wasn't there. He can't say the plaintiff didn't fall because he wasn't there.
Counsel, was there any impediment to your client finding the name of the person who actually did work with the plaintiff on the day in question?
No. But
So why didn't they do that is the next question. I mean, in other words, they could have come forward with the person who was present at the day of the accident, and that person could have said whatever they would have said, maybe something favorable to you all, maybe not. So there was no impediment to finding out that employee, I take it. That's what you said.
Specifically because plaintiff testified that he, didn't work with the same person all the time. Although he did work most of the times with Peru, there were times when he worked with other people. So who would have that information? It would probably be the defendant.
it's our position, Your Honors, that that information is in the hands of the employer, who's a third-party defendant in this matter. But the conflict here between the testimony of plaintiff respondent and testimony of Peru is not just in the happenstance and the witnessing of the fall, but of the origin of the oil pool that plaintiff allegedly...
But again, counsel, Peru cannot elucidate anything, nothing about the day of the accident because he was not there.
You're right.
So whatever his experiences were before he got hurt and quit the job, tell us nothing about what the conditions were on this day. So unless I have testimony, evidence from someone with firsthand knowledge who was there that day, so is there anything else in the record beyond Peru who really doesn't help you because he was not there on the day that the accident occurred and had not been on site for a while? So that doesn't help you.
There's an affirmation from the plaintiff's supervisor, Abraham Diaz. He was the foreman on site. While he did not witness the incident, he was the site safety manager. He was in charge of receiving site safety reports. He testified that he had no knowledge of this incident until the plaintiff filed a claim for workers' compensation benefits. Moreover, Mr. Diaz's affirmation rebuts the plaintiff's assertions. I see my time's elapsed.
Go ahead.
May I briefly
Go
conclude?
ahead, please,
Thank you.
continue.
Thank you. The affirmation of Abraham Diaz specifically rebuts the testimony of the plaintiff that his motor, the one that broke allegedly on the date of the incident, causing the pool of oil, had broken repeatedly over the 6-month period while the plaintiff was working on this site. Mr. Diaz, as the site safety manager, would have been the person to whom plaintiff reported any defects in any materials, any need for repair. And just like he had no record of...
All right. This man falls off of a scaffold that's being lowered on the side of on the front of the building, right? Or one of the sides of the building, right?
Yes.
And the scaffold has railing on 3 sides of it.
Yes.
But not on the side that's against the building.
Right.
Right? And it's through there that he falls, correct?
My understanding, Your Honor, is the plaintiff slipped on the the puddle of oil.
Right,
on
and
the scaffold
falls.
and remained on the scaffold.
Right, and he falls through the side that has no railing, correct?
Correct.
Okay, so under 240, all scaffolds have to have railing all the way around in order to prevent exactly this from happening. So, what was put in place to protect this worker from falling?
The plaintiff was wearing a harness. The plaintiff provided his own harness. That harness was clipped into the scaffold, but that did not protect the plaintiff from falling here, as alleged.
Okay,
Thank you.
all right, you'll have time on rebuttal.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. I was going to make the argument that, I was going to refer to what Judge Moulton said about that what they could have done is produce the very coworker that was there that day. He's the only person that has firsthand knowledge of a couple things. One, what happened to the plaintiff, but 2, the condition of the scaffold at the time. Not how it looked when Mr. Diaz allegedly inspected 14 times before the accident, but how did it look on that day? And the only person other than the plaintiff is the coworker. So with regard to that, that's fatal to opposing summary judgment. In addition, our position is Mr. Diaz's affidavit actually helps us. I mean, if you look through the procedural issue, which I think you should, because this court has held that 2309 is a procedure, it's not a fatal defect. Okay. If you look at it, it actually helps us, because what does he say? At 747 of the record, paragraph 6, Mr. Diaz actually didn't say the accident didn't happen. All he said was that he didn't witness it. If you look at 748 of the record, paragraph 11, he says, paragraph 10, he talks about his personal inspections. But as you know, under your precedent, including Kafisi against L&L Holding, which is 219 AD 3rd 1215, any prior inspections and anything that you did prior to the time of the accident doesn't raise an issue of fact as to what was happening at that moment. So that doesn't help the defendant or raise an issue of fact. And with regard to the next paragraph.
What about the fact that Diaz said that he didn't hear a boo about any accident on this day until the workers' comp claim came in?
Well, I mean, plaintiff did testify that he reported it to Mr. Diaz in his office, which one may say, well, isn't that a question of fact? Which I would say no. It doesn't go to a material issue of fact because it still hasn't been refuted that this incident occurred the way plaintiff said it did. And one other thing I think that is important to emphasize is that plaintiff never came back to work. So, I mean, he never came back to work. I would say the fact that he technically didn't create an incident report, maybe that will create an adverse inference against them for not creating a report. It's just
we
that he
make
never
of-
came back to work, so.
What should we make of the allegation of plaintiff that he fell 1.5 stories on his back and didn't go to the emergency room until about a week later?
I think at this point in this record, without anything other than plaintiff's testimony, I think you'd have to credit him that he got up and he thought he could continue working. He hoped that he could continue working. He left the site, went home, was home for a week on heavy Advil or whatever else he testified to. It's in the record. And that a week later, after not feeling better and not being able to function, he then went to the doctor. I don't think it, again, I'm not, I think that a jury needs to determine that with respect to maybe his damages, but with regard to whether he was injured, again, all we have is his testimony that he fell 1.5 stories, and he did testify that he was really injured and he was incapacitated at home. So there's no records in the.
Do we need, in order to find for the plaintiff on 240 sub 1, do we need to have a defective motor on the scaffold?
No, because you have other violations, right? So the scaffold tilted, the scaffold moved, and the scaffold. So even if you don't have the issue of the motor, I mean, you don't have the railings, and you have it tilting, and you have it moving, and it was insufficient as a matter of law under precedent, under this court's precedent, separate from the fact that the motor was leaking oil and that he slipped, although you could also have 240 when slipping is part of and creating an elevation-related hazard.
So to find for the plaintiff on 240, whether or not the motor was smoking or leaking is irrelevant because the scaffold itself did not provide the required protection because it was missing a railing.
Correct, and it tilted and moved, and so it didn't provide its, the core purpose was to prevent him from falling, and it didn't do that, so it's insufficient as a matter of law. If you have any other questions, I'll rest on my brief.
Thank you.
Thank you very much.
Counsel, you have a minute.
Thank you. The affidavit of the plaintiff's foreman, Abraham Diaz, directly rebuts the allegations of plaintiff, and it should have been considered.
But he may rebut the allegations of plaintiff with respect to a defective motor, but does he say that the scaffold had railings all around?
No, the scaffold did not have the rings all the way around. It did not have the fencing on the side closest to the building.
Does Mr. Diaz tell us exactly when he last inspected the motor on this particular scaffold?
Prior to the incident, he does not.
Doesn't our case law require that?
It requires that, but separate from that, Your Honor, the affirmation should have been considered below and should be considered here because although it was notarized out of state, may I briefly?
Please.
Thank you. Although it was notarized out of state, it's not a fatal defect, as this court has repeatedly held. And Mr.
Counsel,
Diaz,
didn't you cite a lot of Second Department cases in your brief about that? And you said they were First Department cases, but they're Second Department cases, aren't they?
the majority of the cases I cited were from the Second Department, but my position is they should be persuasive as there was.
You want to be careful when you say this court because we're different than the Second Department. I'm sure the Second Department would say the same thing about us.
Thank you so much.
Thank you.
Munos versus JDS Seager.
What about Mizek?
No.
Oh, Munoz.
Oh, Rosanna.
Oh, I'm sorry. I called you out of turn. All right. Do you mind? Give me 1 second. Forgive me. I'm getting notes from my colleagues. You're calling the wrong case.
Right. Please, Zach.
Sorry. Mizek versus Rosanna. You guys are next. My apologies, okay? Yes, and Judge O'Neill Levy is recused, same as before. If we have a tie, we will go to our rules and vouch someone in. All right? You may proceed.
May it please the court. Bruce H. Letterman from the firm DL Partners for the defendant appellant. Whenever there's a fraud, and particularly an attorney fraud or misconduct, it's almost always possible to reverse engineer and find some reason that you can argue you should have known better. But that's blaming the victim. And this court should not countenance blaming the victim, which is really what the respondent would like to do here. The record is
Who's
clear.
the victim? You're, Mr. Rosanna is the victim?
He's the victim of an attorney who's been arrested, who didn't show up, who emailed
He
him.
had, I mean, correct me if I'm wrong, but he's had 4 sets of lawyers who serially failed to provide discovery in this case, right?
That's not correct, Your Honor. There were 3 sets of attorneys. What happened here, when the complaint came in, and initially the white shoe firm of Kasowitz Berenson put in an answer. That was his firm's corporate attorneys. Then this case, which he views as a relatively small case, he brought in a real estate lawyer that he knew, Mr. Krause, for a short period of time to try to settle it. And then he brought in Mr. Struzzulo when it turned out it couldn't be settled. The 4th attorney was just an associate of Mr. Struzzulo.
Did anybody of these lawyers participate in the drafting of PC orders for the court? Preliminary conference orders. In other words, did any of them do the sorts of things you got to do even if you're not settling the case?
It was just the attorney who worked for Mr. Struzzulo, the woman, I forgot her name for a moment. There was a PC order. She resigned.
But there was a PC order before that,
With the first,
under Kraus.
Yes. But this case was still...
No, not but this case. There's a preliminary conference order. The court has ordered certain discovery. It's not a suggestion, it's an order.
Yes.
And they were not abided by. So why should there be relief here for your client?
Your Honor, neither party participated in discovery, and the plaintiff moved for summary judgment. There was no request for an order of preclusion or to enforce the PC. The plaintiff chose, without any discovery, to move for summary judgment.
That
That's
begs
what was
the question.
unopposed.
I asked for discovery, I don't get any. I asked for it again, I don't get any. And in the meanwhile, we're playing the, whack-a-mole with new attorneys each time the case is in front of the court.
Well, again, Your Honor, an attorney was hired, a licensed attorney. He was paid a retainer of $50,000.
That's great. All I care about is, did the attorney, on behalf of his client, abide by the PC order and provide the discovery required?
As I said, neither party did, and then there was a motion for summary judgment. So it wasn't a matter of there was a...
Was not opposed.
Excuse me?
No one opposed that motion.
Yes, well, that's why, Your Honor, I say Mr. Rosanna was a victim, because his attorney didn't oppose it. When Mr. Struzzulo's associate resigned, he immediately wrote and said, "Are you handling it?" Mr. Struzzulo said, "I'm handling it." This is at page 483 of the record. Then there was an order which got transmitted to Mr. Rosanna by a prior counsel who was on it, saying you have to file reply papers, and oral argument is on November 1. And at page 485 of the record, it shows that he said, "I'm on top of it."
And then he didn't appear.
And he didn't appear.
But the thing is that it's not just him not appearing. It has been a pattern. It has been a pattern, in essence, by all the attorneys that have represented Mr. Rosanna.
Well, again, Your Honor, respectfully, the cases I cite in my brief, this court has said multiple times there shouldn't be a judgment based upon attorney neglect. This was attorney neglect. There is a very strong, and I haven't even had a chance because you've asked numerous questions, which I'd like to address. There's a very strong meritorious defense that my client believed was being asserted. My client, and again, to the record at page 480, 481, 483, kept writing, "Are you handling this?" And he kept being assured he was. There's an email in the record. He said, "I'm handling it. My uncle passed away. I'm going in front of the judge right now." So there was clear intention on my client's part to defend this case. And if you look at the record and you look at the cases cited in our brief from this court, the question is, did my client intentionally default? This wasn't a matter of a motion for an order of preclusion or a motion to compel discovery. There was a freestanding summary judgment motion. So I submit that establishes a reasonable defense. Now, If I can have a few moments, I didn't get to
We'll
talk
have
about
time on rebuttal. Go ahead, you can ask your question.
We're looking at the reasonable excuse for the default.
Correct.
Yeah. That's what we don't see.
No, I again suggested I'll address it on rebuttal. Thank you, Judge.
Thank you.
Good afternoon. David Pellegrino for Respondent Matthew Mizak. There are at least 4 reasons why this court should affirm the denial of the motion to vacate. Number 1, there is no reasonable excuse because Rosanna was aware of Strzezulo's failures at every step of the proceedings. Number 2, Rosanna was not taken advantage of by his attorneys. In fact, he had a kitchen cabinet of attorneys advising him in addition to Strzezulo. Thank you for smiling at that. Number 3, Justice Ostrager gave him the opportunity after opportunity, and when he finally gave him a last chance to submit opposition to summary judgment, Rosanna knowingly decided to let the date pass. But finally, although that the summary judgment proceedings lasted 4.5 months, and that reflects willful neglect, that pattern began well before the summary judgment motion. And
It happened after your client signed the Oak Hill transactions. The attorneys went dark, correct? That's why we're here today.
That's correct. Our client's responsibility was to sign the documents. He performed, and Rosanna did not. And I just want to say that a court should not excuse a default when, as here, there's repeated and persistent failure to comply with the party's litigation obligations. Significantly, my adversary here says that we did not comply with discovery. That is completely false, and if the court takes it, our responses to discovery are not part of the record, but I ask that the court take judicial notice of dockets number 76, 77, and 78. He also had previously said that we did not attach the Blue Mountain MIPA, which stands for Membership Purchase Agreement, to our summary judgment papers. That is, in fact, attached to, hyperlinked to our papers, and as well as the verified.
Counsel, their argument, their main argument is, we have a meritorious defense because we, to the extent that we find that there was an agreement, your damages are restricted to your, it's liquidated damages, whatever down payment you gave. That's all you can get back. That's their argument. So that you would be getting a windfall if you get if we allow this judgment to stand.
That is their argument. Number 1, without a reasonable excuse, you never get to meritorious defense. But the meritorious defense is completely made up. They're relying on a form that was mentioned in the agreement that simply said the parties would start with the form. And contrast that with the provision within that same agreement that talks about a guarantee that would be included. And in that document, the parties specifically agreed that they would use comparable terms. They did not go that far with respect to the Blue Mountain MIPA. And in any event, that argument was not raised below and should not be countenanced today. To the extent I haven't said it enough in my brief, appellant's arguments here were not raised below. They are substantially not part of the record, and they are substantially false.
Which arguments?
Which are substantially false?
No, which arguments were not raised below specifically?
Specifically, this liquidated damage provision. That was not an argument that was made below, and it's their primary argument before this court now.
Okay. All right. Thank you.
The court has no other questions. I'll rest. Thank you.
Again, where I started on the reasonable excuse, this is a question of what Mr. Mizak believed with regard to the summary judgment motion, which the record is clear that he instructed and his attorney told him he was responding to. On the question which Judge Mendez asked about the merits, the February 4 email, the very first sentence, talks about that the agreement will be based on the Blue Mountain MIPA. Well, you have to understand here, and there's a mischaracterization, the whole point is the guarantee is simply a guarantee of what's in the Blue Mountain MIPA. So if the maximum damages under the Blue Mountain MIPA are $300,000, as you say, it would be a windfall. And again, going to the issues being raised, The fact that they are saying the deal was a $6 million deal, no liquidated damages, and my client is saying the very first sentence of the document says, agreeing to agree, we will start with the form of the Blue Mountain MIPA, and the email talks about a deposit of $300,000. That is what my client had in mind. And again, Judge Rosado asked about you going dark. It wasn't that we went dark, Judge Rosado.
Yeah, you got the money, and then there was no more communications.
No,
That's what she's talking about.
Respectfully, what the
But
record...
what are you going to tell me, that there were 11 drafts of the MIPA?
Correct. And
Where are they on the record?
they're in their affidavit. The negotiations went on
Can you
through
tell me where
multiple
in the
drafts.
record, and I will look for it, counsel?
I don't recall right now, but in their papers, they say there were multiple drafts going back. And the issue which held it up was in their version of the contract, they changed the liquidated damage provision to say we have a right to specific performance. And I think this court would recognize that in a real estate type transaction where you have a deposit, the standard is that the deposit is liquidated damages.
All right.
That's what's in the...
Thank you.
All right, thank you, Your Honors.
Thank you.
Munos versus JDS Seager.
Good afternoon, Your Honor.
Good afternoon.
My name is C. Briggs Johnson on behalf of the appellant Samponia. And so I guess I want to start with the objective evidence in this case, right? So we have the JDS daily logs, which Mr. Hirsch from JDS created in real time as the project was progressing. And why does that matter? That matters because he's saying over and over and over again in these daily logs, not only did I install the metal plates, JDS, for the project, but Samponia did not. We put wooden forms in, we poured concrete, we removed the forms, that's it. And that's all over the daily logs, okay? Then we go to the contract, the second piece of most objective evidence we have in the record, created close in time to the project. Samponia is, a direct quote, is required to furnish and install all entry-level concrete stairs and lightweight concrete on metal deck. The metal deck that's already installed by the steel contractors, right? And then there's a rider to the agreement where it says that the steel contractor is responsible for furnishing, providing, and installing all metal deck or Q decking, the mechanism of plaintiff's accident. We go to my client's testimony. He says, all I've ever done on every single project in my entire life.
No, it's kind of sparse, but doesn't Mr. Hirsch's EBT testimony create an issue of tribal fact?
You know, I think in most instances, I would agree with you, right? But this is not like where we have one witness and another witness conflicting with each other. Earlier on in his testimony, I want to point you to 580.
Yeah, I'm looking at it.
He remembered that Samponia performed the concrete slab work, the foundation work, the concrete stairs at the entrances, and I believe that's it.
Yeah, but this is part of a litany. I mean, you were kind of, the person doing the EBT questioning at this time was going through the roles of the various players, I think,
Right.
at the construction site. So, I mean, you could say that that's what their main job was, but not that they weren't also covering up gaps that could have been a safety hazard at the work site.
True, but the problem he has with his testimony here is the JDS logs that they created in real time that he created when the accident is fresh in his mind, when the project is fresh in his mind, right? We've seen documentaries. I know you see many criminal cases where memory is a huge issue, and as time goes on,
Civil cases too.
civil cases, of course. You know, I couldn't tell you what I had for dinner yesterday. I know it was chicken. I know there were sweet potatoes, and then I went to sleep. I had a seltzer, but you know, and the initial portion of his testimony is saying concrete slab, concrete slab, concrete slab. Everything else in this record is showing the 4.5 pieces of evidence, if you want to call it, that we never did this stuff. And JDS is admitting not only that they're responsible for fall protection on the project, but that they installed these plates a couple weeks before the accident. So you could say that, you know, in most cases that there might be an issue of fact as to whether we did it, but when you have 5 pieces of evidence saying no, And then later on in deposition after his lunch break, he's like, yeah, Samponia installed the Q decking. I don't think that's enough. And
You also say kind of repetitively in your brief that the fact that Samponia admitted they put the plywood down after the accident is evidence of something. But usually that's not evidence of anything that's admissible.
No, the only way that a post-accident remedial measure, if you will, is admissible is if the issue is control or ownership or control of the mechanism producing the injury.
Exclusive control, I believe.
Exclusive control, right, of course.
And they weren't exclusively in control of that place.
Of course. I mean, JDS was, and the steel contractor and all the other contractors. I mean, the walls weren't completed yet.
But if I'm understanding your argument, you're basically saying most of the time he was consistent. So just ignore that one time he wasn't. That's not how this works.
I understand what you're saying, but I'm saying all the other evidence, the objective evidence created close in time to the accident, Mr. Samponia, I mean, the contract between us and JDS.
No, I get that. I get that. But we cannot make credibility determinations about what part of the testimony we're going to accept and then reject, right? Either the testimony creates an issue of fact, either in itself or outside, but that's our test. It's not, most of the time we can't do it that way, right?
I agree in most instances, but the case law I cited in my brief regarding feigned issues of fact and incredible as a matter of law, the Merhani case.
Incredible as a matter of law? Wow, that's a big one.
Well,
that's a
understand.
big, gigantor leap you want us to take on this one.
I understand
statement.
your point, but I'm saying if we look at the evidence close in time to the accident that there is no controversy over, it points to JDS installing these metal plates and us pouring concrete, removing the wooden forms, and then moving on. And so, unless there's any other questions.
Okay.
Thank you.
Thank you.
Good afternoon.
Good afternoon.
Court. My name is Richard Polner. I'm an attorney with the Office of Roland Henderson, here for appellants RCI Plumbing. Ultimately, there's only one cause of action still remaining against my client with respect to third-party plaintiff, and that's for contractual indemnity. And that contractual indemnification claim is based solely on supposition. As has already been pointed out, it is essentially the belief of JDS's witness that this particular item was placed by Samponia, and therefore that would be the only thing that could possibly protect them from this being the cause of the condition being the sole negligence of JDS entities. So unfortunately, there's nothing else in the record for the purposes of evidence that would support that contention that this was placed by JDS, and ultimately it was determined by the trial judge that this was not performed by Samponia. In the judge's decision, said the record reflects that Samponia was not delegated the duty to install or maintain hole covers at the project, nor did it install Q decking. So if we're looking at this as the prospect of this being an installation, it was not performed by Samponia. The only entity it could have been performed by would have been JDS, as JDS is the entity that acknowledged they're the ones who were responsible for protections on the site, which included hole coverings. This was a floor opening. There's been no testimony that any work was being performed in this hole at any time around the time of the incident. There's been no testimony as to what this hole was ultimately to become. There's no indication that it was supposed to be part of Samponia's work or any other entity on this project. So based upon the evidence, and now that discovery is closed, you're essentially leaving it to just into the ether that this could have been caused by someone other than respondents, and there's absolutely no evidence to support that. Unless you have questions.
Well, you had a contractual argument as well, right? That you didn't have to indemnify the JDS.
Well, that is our sole argument, is that ultimately our challenge is not necessarily that contractual indemnity may not be owed, but in this instance, it can't be under any construction of the
Because it does seem to me that the JDS entities are indemnities of RCS. It does seem that way to me.
That's what
You
I'm
concede
saying.
that, basically.
Conceding that the contractual indemnity in the broad-based language of the indemnification provision, considering there are two conflicting indemnification provisions within the contract, that ultimately the broader language ultimately trumps the narrow language. But that's not the argument here. The argument here is that you would ultimately be requiring RCI Plumbing, having absolutely nothing to do with this incident, to indemnify the third-party plaintiffs who are the sole reason why this incident occurred. They're the ones who had responsibility for this opening, and there is nobody else that they could point the finger at that they could say ultimately failed to fulfill the obligation of ensuring that this opening was properly covered.
Okay, got it.
May it please the court, my name is Chris Donadio. I'm counsel for the plaintiff respondent to Sampagna, defendant appellate Sampagna's appeal. I'm with the law office of Garrett Conason. We believe the IAS court was correct in denying Sampagna's summary judgment motion based on the testimony of Adam Hirsch. We don't dispute what the logs say. We don't dispute what the contract says. However, JDS's witness, Adam Hirsch, who was the superintendent of the entire project, who was there most days, who was in charge of all the work, testified that Sampagna was the entity who had workers who were responsible for securing the queue decking, which my client stepped on and fell on. Whether that testimony is believable or not, that testimony is for a jury to determine its credibility, not for, Your Honors, not for the lower court. The only way that that testimony could be thrown out is if it was speculative, if it was feigned, or if it was incredible as a matter of law. There's nothing incredible about saying a concrete contractor would be responsible for securing a deck. In regards to it being speculative, the cases cited by counsel in the defendant appellant's brief are all situations where the testimony had language such as, well, maybe it was possible the defendant did that, or I think someone else had something to do with that. That is not the language we're dealing with here. Mr. Hirsch was quite clear, Sampagna is who was responsible for that. Regarding the feigned testimony, the question as to whether it was contradictory, it was very clear early in the examination before trial when Mr. Hirsch was being asked about the concrete and masonry responsibilities of Sampagna, he listed those. He was specifically asked about concrete and masonry responsibilities. Later in the deposition, he talked about some of the other things that Sampagna did, including securing queue decking, which was what caused the subject incident in this case. If there are no questions from the court, we again believe that the lower court decision should be affirmed. Thank you.
May it please the court, Nitin Sain from Kennedy CMK LLP for the JDS entities. So just want to touch on the two documents that the appellants have raised. The daily logs do not say that the term metal equals queue decking. They keep saying that's what it should mean. The witness never said that. With regards to the contract on the record, page 904, it explicitly states the scope of work includes but not limited to. Furthermore, it's on page 905, it says provide all labor and material. Mr. Hirsch, the only witness that was produced, was actually on the job site and had actual knowledge of what was being done by the contractors and the people there, was specific that the queue decking to be placed was part of Sampagna's work. Furthermore, there are photographs that show queue decking being removed while Sampagna's work is being done. They keep trying to ignore that part. There was testimony about whether they would move material up and down and remove an opening. They did that. So the lower court found there are question of facts, not only whether they were responsible for that, but whether they removed something that created the condition which resulted in the accident. So with regards to the question of RCI, they readily admit the contract applies to them. My clients are an indemnity under that. The question is whether they're entitled to full or partial indemnification for RCI. They're not disputing that. The question is an issue of fact that needs to be tried before a jury as to what was the sole proximate cause or partial active negligence on behalf of the entities here, and the lower court ruling should be upheld. Should you have any questions, I'll rest on the brief.
Thank you.
Thank you.
Counsel, you have 2 minutes.
Your Honor, I think we addressed everything in the initial argument. If you have any questions, I'm going to rest on everything in my brief.
Any questions? Thank you.
Thank you.
Just quickly, Your Honors, one thing that should be pointed out is with respect to whether or not the JDS entities are entitled to indemnification, counsel has pointed out that they would be entitled to either partial or full indemnity. What they seem to be leaving out is they could be entitled to none. And ultimately, that's really the issue here, is that there is no evidence with respect to what entity placed this other than someone's belief that it may have been placed by an entity other than their own. I think without something to support their contention that this condition was caused by someone else, when there's an acknowledgement that the protection for this condition fell within their contractual and their own, as owners, their responsibilities, you can't then impart that responsibility on someone else without something to back it up. Thank you.
Thank you. Okay. People versus Yuri Wilson. You may proceed.
Good afternoon, Margaret Knight from the Office of the Appellate Defender on behalf of Mr. Wilson. The court erred in refusing to charge attempted assault in the third degree as a lesser included offense. There was a reasonable view of the evidence that Mr. Wilson only engaged in a fist fight and punched Mr. Quintero.
How can we reach that? Because for me, that's the trouble for me, right? I have a doctor who says this victim was stabbed, punctured by something other than a cell phone. It could not have been a cell phone. He describes the depth of the puncture wound, etc. So in my mind, there is no issue about whether this man was stabbed. And so if that is my observation based on the video that we saw again and again and again, if I conclude that there was a knife and that a knife injured this victim, does this argument hold any water?
Absolutely, Your Honor. There's a reasonable view of the evidence that Mr. Wilson was not the person who inflicted that stab wound and that he had no knowledge about who inflicted the stab wound or that there was...
But your theory is it could have been someone off camera who inflicted the stab wound. You're not saying that there was not a stab wound.
Yes, Your Honor. And there is a reasonable view of the evidence. I mean, that was the argument that the prosecutor made in expanding this case to an act. They got an acting in concert charge specifically by asking, there's a reasonable view of the evidence that the stabbing occurred on camera. There's a reasonable view of the evidence that the stabbing occurred off camera. So once they get that acting in concert charge, then Mr. Wilson is allowed to argue that he had a reduced role in the offense, that he was only engaging in a fist fight, and that if someone else came in and stabbed the victim, that he did not intend to do that. He did not share that intent, that the knife, there's no evidence that the knife was otherwise open and obvious, and that he was...
Was the knife in his hand or in someone else's hand?
Well, the prosecution initially argued in their opening that the video depicted Mr. Wilson personally stabbing the victim. Over the course of trial, as defense counsel made arguments that there would have been additional injuries if Mr. Wilson had a knife. The prosecution also conceded in opening that the video was grainy. So the prosecution realized as the case went on that there was an argument that the jury might not accept that the stabbing happened off camera and that the stabbing instead, or that the stabbing occurred on camera and that it instead occurred off camera. And once that was the prosecution's argument.
Sure, counsel, I take your argument, but it sure looks from the video like he's got something in his hand and he's making a movement that looks less like a punch and more like a stab. So how do you get around that? You do say, I know in your brief, that the rapidity with which he punched and then switched to the sort of more stabbing motion means that how could he have possibly gotten something that, the instrument necessary to stab the victim? You say that, I guess, is that how we say that the video is not what would appears to us?
In terms of, I mean, we also make a weight of the evidence argument, but in terms of the lesser included offense, the evidence needs to be viewed in the light most favorable to the
Right, but if I look at the video and I say, I see a knife, and I see him doing this to him twice, if I see that, do I need a lesser included charge?
Yes, absolutely, because you may believe that, but the jury could believe something else. And the prosecutor argued themselves. I mean, the prosecutor argued that there was a
Well, that may
reasonable
have
view
been
of
their
the evidence.
mistake, but
The court accepted that there was a reasonable view of the evidence. The jury asked about accomplice liability. The jury would never have asked about accomplice liability if they also thought the video so clearly depicted.
Well, that was charged. That was
necessarily,
charged.
yeah.
So they're going through everything that's been instructed. That's what they're doing. They're deliberating.
the fact that they asked doesn't mean that they were caught up on it.
Even so, just looking at the evidence, this has to be viewed in the light most favorable to the defense. Mr. Rahman did not see a knife. There is, we would say that that shadow on the video is not clearly a knife. The prosecution conceded.
But so I mean, the problem I have with that is if, in the same way in law school, they would say, if you're outside and you see somebody come inside with an umbrella and the umbrella is wet, you don't see outside, so you don't know whether it's raining, but you can infer that if the umbrella is wet, it's probably raining outside, right? And so, in my mind, if I see this twice, and then the testimony of, because I'm not just looking at the video, but mirroring the video with the testimony, and it seems like after that melee, when Rahman pulls his friend back, and the friend doesn't even realize in the midst of it all that he's been stabbed. But they're running away. So I don't recall there being additional altercation after he's pulled away.
There was, Your Honor. Mr. Rahman testified that once the fight moved off camera, that Mr. Wilson and another person, Mr. Traore, were continuing to hit the complainant. So there was a part of the fight that happened off camera, and that, again, is part of the reasonable view of the evidence, that this stabbing did not occur on the evidence. Again, that's what the prosecution argued to get acting in concert. And under that situation, Mr. Wilson was entitled to a charge that comported with his theory of the defense, that all the video showed was him punching the complainant.
Okay.
Good afternoon. May it please the court. Sarah Lubin for the people. The court below was correct in determining that attempted assault in the third degree was not an appropriate lesser included in this case because there is no reasonable view.
Why isn't counsel's argument valid that there is no depiction of this entire fight? There are parts of this fight that are outside of the viewing of the camera, and your victim's own account doesn't seem to support he was unaware that he was stabbed, right? So he's in the middle of this fight. He's unaware that he's stabbed. It's not until he's walking away with his friend that his friend sees him bleeding.
That's correct, that it's not in.
So why is it unreasonable to infer that perhaps in the second melee off camera, that the stabbing may have occurred then?
So, given the accomplice liability charge, it's our position that attempted assault in a third degree would not be appropriate regardless, because there's no reasonable view that there wasn't a stabbing. That in order for attempted assault in a third degree.
There could have,
go ahead.
There could have been a stabbing, but he would have been exempt from accomplice liability because he was not aware that someone had a sharp instrument at the fight.
And if the jury were.
And so just to follow up on that, I mean, it seems to me that actually the charge of accomplice liability helps the defendant because the court seems to be saying that there's a possibility that the defendant did not do the stabbing, but rather it was done off camera by another person involved in the melee.
And the court below, when the judge below gives his reasoning for not giving assault in the third degree, he sort of touches on this, that in this case, the defendant is charged with 2 counts of assault that involve a dangerous instrument. And so as it was charged to the jury effectively would need to find that either acting as principal or acting in concert, the defendant used a dangerous instrument to cause the injury.
No, acting in concert, the defendant would not have to necessarily use the instrument.
Pardon, I misspoke. Or acting as an accomplice in the use of the dangerous instrument that caused that injury, because there's no reasonable view that that injury didn't occur at some point during this fight. So either, and I believe the words of the judge below were in for a penny, in for a pound, that either
That's the part I totally do not understand. What does that mean in this context?
It's our view that what the judge is saying is that either the jury is going to find that the defendant acting as a principal or as an accomplice in the use of the dangerous instrument caused the injury, or otherwise the defendant is entitled to an acquittal, is effectively what he's saying, that attempted assault in the third degree would not make sense because there's no reasonable view if you find that there was an injury and that by that same conduct.
If it was the accomplice, right, who actually did the stabbing, under our case law, wouldn't the defendant have to have known that that accomplice had a knife?
That's correct.
And how was that established?
In this case, it really would only be by speculation, because you're correct that the assault, once it moves off camera, we don't have any evidence directly tying the defendant to the stabbing, or any evidence really directly at all to explain.
But then how does speculation meet the threshold of beyond a reasonable doubt?
That would have been against the weight of the evidence.
It wouldn't be against the weight of the evidence, because we don't know how the jury decided this. Then it really was the main theory that the people put forward was that the injury occurred on video. That
this is the problem when you charge alternative theories, right? That then you're arguing in both directions, and it's hard to assess which direction the jury took when they come back with a verdict. We don't know, because there's not a specific question telling us, did you find him guilty as the principal or as the accomplice, right?
That's correct.
So that's problematic here.
It's really our position that the stabbing is what we see on the video. That instance in the video, that I believe the court has seen the video at this point. If not, I'm happy to provide it.
No, we haven't.
That point.
I would agree with your interpretation, but, counsel points out, well, that's nice. It's the jury that matters, not you, Judge, and she's right.
It would still be our position then that attempted assault in the third degree would not be a lesser included, given that it's not the same conduct that the defendant was charged with. The defense counsel is saying that he could be held accountable for this other lesser assaultive behavior that may be seen on the video, but that's not the conduct that the defendant was actually charged in. This is an indictment that only contemplates an injury caused by a dangerous instrument. That's the only cause of injury that's consistent with the injury the victim sustained in this case. And so to allow attempted assault in the third degree is allowing the defendant to be found guilty of something that he effectively wasn't charged with.
But doesn't it go along with the accomplice liability? Isn't it tied together? If he has the accomplice liability, then they would consider the attempted assault 3, if they were going to be considering that.
If they were,
like once they have this charge of accomplice liability, what if they were just focusing on that? Counsel's point is then they needed to also consider the attempted assault 3.
Which I believe is part of the court's reasoning below, is that accomplice liability charges would not make sense with a charge of assault in the third degree, that the accomplice liability charge would be inconsistent with then saying, no, this other assaultive behavior that we may see on the video, and I believe this specific behavior that defense counsel is referencing is a point where the defendant appears to throw a punch right before the stabbing motion, that doesn't make sense with that accomplice.
Well, I think she's suggesting that there was an additional altercation outside of the viewing of this video, and that the stabbing could have occurred then, and if it occurred then and occurred at the hand of the accomplice, there is no proof in the record that the defendant knew that the accomplice had a knife. I think that's her argument. But I've heard yours, and thank you.
Thank you.
You have 1 minute.
Yeah, very briefly, this argument of the same conduct is not grounded in the law or the facts. The prosecution certainly never argued that below. It's what there is a reasonable view of the evidence here. And the court found that there was a reasonable view of the evidence. The court's ruling was if you don't accept the idea that other than the in for a penny, in for a pound, which I agree does not make that much sense, but if you don't accept the idea that Mr. Wilson either was stabbing somebody or he was acting in concert with another person that was stabbing somebody, there's no view of the evidence that he was intending to cause physical injury somehow. In fact, the argument was that defense counsel repeatedly punched the victim, and that was attempted assault, and the jury did not get to consider a charge that comported with that defense.
What about the point that if we allowed assault 3 to be charged, and he was found guilty of that, he would be found guilty of something that was not in the indictment, of a charge that was not in the indictment? Does that matter?
No, I mean, he was charged with assault. He was charged with attempted first-degree assault and second-degree assault. Based on this incident, the prosecution opened by asking the jurors to look at the video. What do you think this is? Their theory was that it was a stabbing. Defense counsel said, no, 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 that's a punch. So that is the conduct that was at issue, and defense counsel was entitled to any charge that reasonably comported with the evidence. Here, according to the defense theory, that was attempted third-degree assault.
Okay, but assault 1 and assault 2 both require a sharp object, right?
Yes, and that's exactly the problem. He was deprived of a charge that did not involve a sharp object, so the jury did not have an opportunity of considering a count that did not involve a dangerous instrument.
When according to the defense, he didn't have a knife on him or a sharp object on him.
Yes, Your Honor. That is what defense counsel, that was his opening on page 26. Mr. Wilson got involved in the fight. His intent was to use his fists. You will see that from the video. Thank you.
Thank you. All right, next case on the calendar is Pichon versus Sabor. I am recused on this matter. Justice Moulton will be calling the calendar. If there is a tie, we will follow the AD1 rules and vouch someone in.
Good afternoon. May it please the court. My name is Nicholas Tam from Shab Omni Citron and Spratt, and I represent the appellant, Dr. Nejat Kaichi, in this case. The motion court's order should be reversed because the plaintiff, Dr. Kaichi met his moving burden, and the plaintiff submitted legally insufficient evidence. First of all, our expert, Dr. Chait, established that Dr. Kaichi established that he appropriately limited his role to performing the endoscopy, the EGD for.
The question is, though, after he had done that and he had ruled out, I gather, the ulcer diagnosis, shouldn't he have referred the patient for an MRA?
Well, our expert indicated that that was outside the purview of his limited role. He was performing the endoscopy, filling in for Dr. Ader, and his role was not that of a surgeon. It was not that of a hematologist. There were splenic infarcts found on the imaging, but that was not his role to.
So that was a vascular issue? Is that essentially the argument of your expert? And so therefore outside the purview of Dr. Kaiichi.
Outside the purview. He came in just to do the scope. And the plaintiff's expert also failed to address.
So he's doing the scope in a vacuum. He's not, as a doctor, evaluating everything that is before him. And therefore, he has no right to opine and give, make suggestions or even order further testing or suggest that further testing be done?
He may, but in this case, Dr. Chait opined in his expert affirmation that that was not indicated. Based upon the CT scan that showed zero evidence of any bowel ischemia, no free air, no pneumatosis, no ascites, no indication that he had some kind of infection brewing, some type of clot or thrombosis or an occlusion, anything involving the mesentery. So that was not.
What about the splenic infarcts? What relevance did that have?
Well, there's no causation. There's no indication that from plaintiff's expert affirmation that connected any of the splenic infarcts to the mesentery. There just was no evidence.
Didn't the plaintiff's internist say that was an indication that there were some clotting taking place, and therefore there should have been a further, more specific study of the superior mesenteric artery to make sure that there was no damage occurring there or a possible occlusion in not too far into the future as occurred, and therefore that's why a MRA should have been ordered.
So a couple things, Your Honor. First of all, that opinion is completely speculative. There is no connection. There's no connection between the splenic infarcts and the eventual clot that went to the SMA. He was negative in all of his clinical signs, and there was a venous Doppler study done that was negative. What happened was they did do a scan, they did do a CTA imaging scan with IV contrast that was negative. So there is no indication from Dr. Kaiichi's standpoint to do anything further, and this was actually admitted.
I'm sorry, counsel, that went forward by Dr. Ader the day before or a couple days before Dr. Kaiichi's procedure?
Pardon me?
In other words, he had that information when he did the procedure that he did, right?
Yes, he did. He did have that information. He appropriately relied on other experts opining on that study.
Counsel, your time is up, and I need you to answer a question for me. The surgeon for the plaintiff says that MRA is the gold standard for early detection. Did you respond to that?
We did respond to that, and I think...
Where? Can you tell me where on the record?
Yes. Our surgery and internal medicine expert opined that the CTA was the appropriate study, and that... I'll tell you the page.
But that MRA is not the gold standard? Did your expert say that?
He did not opine as to whether the MRA was the gold standard, but on page 3814 of the record, he did indicate that diagnosis can be made on the CTA. And we know that's appropriate because on the second admission, there was no MRA done. It was diagnosed on a CTA. And furthermore, just to follow up on that.
But they say that that specific test, the CTA, would reveal an occlusion of the SMA, right, or mesenteric ischemia, when it is occurring, not when it has not yet occurred, but may.
That's hindsight reasoning. If you're waiting for something, that's hindsight reasoning because if it's undetectable at that point, then it can't be found on the CT scan. The CT scan was done, and in fact, the plaintiff's own internal medicine expert agreed that a CTA can diagnose a mesenteric ischemia.
But she also said an MRA, correct?
She did, but she said inconsistently with the other expert that the CT scan, and agreeing with our expert that the CT scan was also diagnosed.
But both experts said that the MRA would have been an early detection of the blood clots that would have eventually found their way.
The early detection of the blood clots.
The MRA, according to the surgeon, is the golden standard in order to find early detection. The internist didn't contradict him on that, did she? She just said you can do a CTA without contrast or you can do an MRA, correct?
So our expert indicated that you can do a CTA with IV contrast on 3809 of the record and indicate that was diagnostic of the issue that eventually led to the plaintiff's demise.
Thank you.
Thank you, counsel.
Thank you.
You'll have time in rebuttal. You may proceed.
Good afternoon, and may it please the court. Ryan Dukeman on behalf of appellant Dr. Ader. As the court has already honed in on, the central issue in this case with respect to Dr. Ader is exactly one thing: whether or not he had obligation to order an MRA, notwithstanding the fact that a CT angiogram was done the day before that definitively ruled out the presence of a clot, which is the only claim of causation with respect to Dr. Ader. They do not criticize any other aspects of his care. It's just he should have done this scan. As our brief indicates, there was absolutely no basis for Dr. Ader to order that test because the CT with the angiogram that was done definitively ruled out the presence of that clot.
Counsel, do any of the experts, I may have missed this, do any of them talk about the proximity of the two hospitalizations and the fact that they came so quickly upon each other? In other words, the patient was in there October 29th to November 4th, I think, and then he came back on November 6th, and he was in grave condition at that point.
Your Honor, what happened in the rest of the admission is something that our experts did not comment on because it is not pertinent to Dr. Ader's responsibility. His sole interaction with this patient was the one consult.
So as Dr. Kiichi's counsel said, it's hindsight. We'd be looking at it with a 20/20 vision.
Yeah, to attribute what happened in the future to that should have impacted Dr. Ader's decision making at the time is 100% hindsight and not the standard for a medical malpractice case.
Well, and I think it's part of the record, he comes into the hospital with abdominal pain of 1010. And the clinical picture basically does not match the pain that he's got in the abdomen. So instead of, although doctors did mention mesenteric ischemia, instead of trying to rule out that specific issue, they sort of like follow and they go after maybe trying to rule out a peptic ulcer. And so that's why he gets referred to Dr. Ader and then to Dr. Kiichi. But still, even after they do the EGD and after he's examined by Dr. Ader and Dr. Kiichi, he still has symptoms. And yet no one thinks about using what has been referred to as the golden standard MRA to rule out whether or not he's got this mesenteric ischemia.
Your Honor, you raised 2 points there that I'd like to address. First is, once again, what happens after Dr. Ader makes his recommendations is not the responsibility of Dr. Ader. He was called in as a specialist to assess the patient for GI issues. He ordered further testing. He did not find out the results of that future testing. He was not involved in the future care. It's not his responsibility for what happened. With respect to the gold standard argument, I'd like to address that because that's very important in this case. That is a misframing of the issue. Whether or not in some other corner cases an MRA can sometimes be better than a CT with angiogram is utterly irrelevant to the relevant question in this case, which is, did plaintiff have clots in his mesenteric arteries at the time that Dr. Ader saw the patient? And the CT angiogram, which plaintiff's experts said is diagnostic, if it is of sufficient detail, was of sufficient detail. And it is the defense experts as well as the interpreting radiologist who all said that it was, that you could see the vessels in sufficient detail. It wasn't obscured by any contrast, and there was no clot there.
Right, and actually, did plaintiff's experts even consider the CTA that was done in this case?
No, they never reviewed it, which is why they cannot raise a question of fact with respect to our experts' position that this specific CT angiogram was diagnostic and it ruled out the presence of clots. Since there was no clot at the time Dr. Ader saw the patient, there's no proximate causation.
But the argument that they make is that, yes, the CTA is diagnostic, but it's generally nonspecific is a first-order test of little diagnostic value for intravessel clotting and ischemia, and that the MRA is the one that is more specific, that actually analyzes the artery and can lead to detection of a small clot.
Your Honor, that is what his expert affirmation says, but that doesn't change the fact that their own expert said, and I quote, that in order to properly rule out mesenteric ischemia, an MRA or CTA was required to properly inspect the vessels of the mesentery. They concede that the CT angiogram looks at the mesenteric vessels. Whether or not specifically targeting that area doesn't matter if there's expert testimony, and there is, which is unrebutted, that it shows the mesenteric vessels in sufficient detail. You don't have to be zeroing in on something for the scan to reveal what you need to know. And what you needed to know was the clot wasn't there at the time Dr. Ader saw the patient, and there's no contrary expert testimony on what the specific scan in this case showed.
Wasn't there an issue of fact for the jury to determine whether or not, after all of the workup was done, and still there's no answer to his abdominal pain, maybe a more specific test should have been ordered to determine what was causing his abdominal pain?
Your Honor, I cannot take a position on that argument because, again, that is factoring in future test results and what happened with the evolving nature of the patient's care. That is after Dr. Ader performed his one consultation on October 30th. Whatever happened the rest of the admission, he wasn't involved. He wasn't there. He didn't make the decision to discharge the patient, and so I can't comment on that.
But now I'm going to ask you what I asked previous counsel that represents Dr. Kiyichi. Is he there in a vacuum, or is he looking at the whole picture? And possibly even, isn't he allowed to opine, to suggest, to even order additional testing for this patient?
Absolutely, Your Honor, and our experts opine that all his care was appropriate. But I would just like to point out that plaintiff's experts never criticize any recommendations he make other than the MRA. They don't question any other aspects of what he did. They don't say it was inappropriate to recommend the testing he did recommend. They don't say his clinical exam was inappropriate. There's absolutely no questions about the propriety of his care. He was appropriately concerned about the GI issues. Going back to your point about the splenic infarct, he was aware of that finding and he recommended follow-up with the appropriate specialty, a surgeon. He's a stomach doctor. He doesn't deal with the spleen. He recommended a consult for that with another person. And what happened with respect to that consult was not his responsibility. He performed his role, and then the patient was put into the hands of the other well-trained doctors who were responsible for his care.
Thank you, counsel. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon. May it please the court. Michael Schultz for the plaintiff respondent cross appellant. It's our position that the Supreme Court was correct in denying the appellant's motions for reasons that have been discussed a lot by the court already. I do just want to start by answering your question, Justice Moulton. You asked if any expert addressed the proximity in time, and our internist does make reference to it. It's at page 5523 in paragraph 55, and he says that when Mr. Pichon, the decedent, re-presents to the hospital on November 7th, there is an extensive amount of mesenteric necrosis that could not have been possible if it had started only after the discharge from November 4th.
There was gangrene in his part of his small intestine, I think. Is that correct?
I'm sorry, I missed the first
He
one.
had gangrene at that point.
Yes, I believe so.
But what about the fact that neither of your experts consulted the actual CTA that was done on the patient?
So, Your Honor, the CTA would not have revealed the results of mesenteric ischemia. The general surgeon explains that it is a general test, and the internist, it's been addressed a lot, but he says that the CTA can be a proper test if done without contrast.
And it was done with contrast here, correct?
Exactly. That's exactly right. I don't want to make light of it, but if I go to a doctor and say, I feel like I have the flu, and they give me a strep test, and they say, you don't have the flu, they send me on my way. If I go to a second doctor, I'm not going to expect the second doctor to read the results of the strep test because it's not testing for the flu. It's not going to show whether I had the flu. Both experts opine that the CTA was insufficient to diagnose the mesenteric ischemia, and it would have been irrelevant even if they had reviewed the CTA results.
So,
What do you, I'm sorry, how do you respond to your friend's argument that your internist said CTA or MRA would be okay?
The CTA would have needed to be performed without contrast. It's
And that's what she states in her affidavit, correct?
inartfully, it's in different sections. You have to read it with context.
Thank you for your honesty.
It could have been written better, I will admit that, but at paragraph 25 on page 5510, she says the CT must be done without contrast, and then she explains at paragraph 58 on page 5525 that it was performed with contrast, which would defeat the purpose of the without contrast. I do want to briefly turn to my cross appeal, the service issue. It's our position that the Supreme Court erred in denying our cross motion and granting the motion to dismiss. It seems from my reading that on this appeal, the only prong of the relation back test that is an issue is the third prong. The Alamo case, the Brown case from this court, agree that
Dr. Oskan says that she says you don't know if she was working at Montefiore at the time.
right, and that was addressed specifically in Alamo. This court's decision, Alamo versus City Dent Inc., 7280 3D 498 from 2010. If you are united in interest, you are charged with notice of the initiation of the lawsuit, notwithstanding that you may not have been employed by the hospital any longer. So in this case, whether Dr. Oskan was employed by the hospital or not.
What if Dr. Oskan started working in Kenya? In other words, doctors go places and they may not stay in touch with their prior workplaces.
That's a good point, Your Honor. The case law in this department has been that by satisfying the united in interest factor in the second factor, they are charged with notice of the initiation of the lawsuit. In the Brown versus Camlet case, it was the Supreme Court New York decision, which eventually became Brown versus Midtown Medical Center. Obviously, it's not binding on this court, but the judge in the Supreme Court there says, my reading of the case law that has been presented from the first department and the second department says that the second prong is focused on notice, and if you're united in interest, you have notice, and the third prong is focused on whether there was a mistake. In this case, there was an oversight in failing to serve Dr. Oskan. It was a good faith mistake. It would be pointless to name her in a lawsuit and intentionally not serve her for some sort of strategic advantage.
Thank you, Counsel.
Thank you very much.
Good afternoon, Alejandra Gill of Heidel Petoni, Murphy and Bach for Dr. Oskan, cross respondent. The first point that needs to be addressed by this court is whether plaintiff's argument was preserved on appeal. The order appealed from in this case is the motion for summary judgment. On the motion for summary judgment, plaintiff did not dispute the issue of the statute of limitations as to the wrongful death claim as to Dr. Oskan.
Didn't he include his prior motion papers that addressed the argument?
Your Honor, those papers were included by our firm on the moving papers. They were incorporated by reference. So yes, the papers were part of the record on the summary judgment motion. However, plaintiff didn't argue that point. And simply the fact that the papers were there is insufficient to say that the argument itself was preserved. Plaintiff's counsel has not cited to any case law where an argument is not, essentially they didn't re-raise the argument, we did. We affirmatively stated this is the issue, the arguments were briefed in the underlying motion. Plaintiff could have said in their opposition to the summary judgment motion, we incorporate by reference our arguments made on the cross motion. They didn't do that. They completely ignored the issue. And in their appeal papers, they mentioned that the court, by specifically referencing those motion papers, clearly considered their arguments, but that's not clear from the court's decision. And as your honors know, a court can certainly consider an argument on the merits even when it's unopposed, which is essentially what happened here. We raised the argument by incorporating by reference our underlying papers. They did not do the same, so the issue was unpreserved.
And Dr. Oskan had attempted to raise the issue of statute of limitations on the wrongful death claim in a prior motion practice, correct?
Correct.
So, and the court just didn't deal with it at that time.
That is correct, which is why it was raised again in the summary judgment motion. And turning to the merits of the relation back theory on the third prong, as your honors have observed, there's no evidence here that Dr. Oskin had a relationship between 2013 and 2014, which is the time when the first complaint was filed in 2013, and then the second complaint was filed in 2014. That's the relevant time period as to the relationship with Montefiore. They served her at St. Barnabas. They knew she wasn't at St. Barnabas, at Montefiore. So to now hold that they were clearly united in interest just is not supported by the facts in this case. The Alamo and the Brown cases.
Do you have to be united in interest at the time that you're sued or at the time that the events take place?
Well, Your Honor, it's our position that the relevant time period is at the time of the suit, because they have to know that is a time period that is relevant, right? Whether at the time that the first action was commenced, they would have known that they could have been sued. And because there was no evidence in this case that Dr. Oskin was united in interest at that time with Montefiore, she cannot then be charged with notice of this claim. The Alamo and the Brown cases don't factually flesh out that issue as to the relationship during the time that the first complaint was filed. So it's our position that those cases are not directly on point with the issues presented on this appeal. If there are no further questions, we rely on our brief.
Thank you, counsel.
Your Honors, I just wanted to clarify something that my adversary indicated. The plaintiff's internal medicine expert actually stated that abdominal CT scans are performed for suspected acute mesenteric ischemia. These CTs should be performed without oral contrast because it can obscure the mesentery. That's page 5510, paragraph 25. However, this expert avoided confronting that the decedent underwent a CTA with IV contrast, not oral contrast. So that's the distinction I wanted to make. The other point I wanted to make very briefly is that in approximately 60 paragraphs of the plaintiff's internal medicine expert's affirmation and approximately 60 paragraphs of their surgery affirmation, they did not mention Dr. Chait's name once. They did not address his opinions. They did set their crosshairs on Dr. Rao's experts and some of the other experts, never mentioned Dr. Chait. Thank you.
Thank you, counsel.
Your Honors, there's two issues I'd like to briefly address. The first is plaintiff's claim that his experts said unequivocally that a CT angiogram is not diagnostic. That is not what his experts said. That is a complete and utter misrepresentation. The language he quotes to from his general surgery about a CT scan being inadequate, that was about a regular CT scan. He never talks about a CT with angiography, which is a completely different test, which is what was actually done in this case. With respect to his internal medicine expert, she never says at any point in those paragraphs that he quotes that it is guaranteed that when you do a CT angiogram with contrast, it is non-diagnostic. What she actually says is that contrast may obscure the mesenteric ischemia. Hypotheticals are not relevant when there are actual scans that you could look at and see what they showed. Since plaintiff's internist expert conceded that you can sometimes see on a CT angiogram with contrast mesenteric clots that are causing mesenteric ischemia, and our experts said that they were, and their experts never looked at it, there is no question of fact on causation in this case. Thank you.
Thank you, counsel.
Your Honors, very briefly on the preservation issue, it's a wacky situation. I will concede that right up front. It's not addressed in our opposition to the motion for summary judgment, but the Supreme Court below in the 2023 decision did not simply reference the papers. On page 17 of the record, the last 4 words of the 4th paragraph down specifically denies our cross motion. This is the first appealable paper on the issue that exists in this case, and it's our position that for that reason, our cross motion is preserved for argument here. Again,
But you're saying you didn't make a cross motion. They just said it, but you're like, it's a wacky situation. It is addressed because it says cross motion.
Well, the cross motion was made in the 2014 papers that were attached as Exhibit H. That's where it gets wacky. There was no decision to the motion to dismiss in 2014 and the cross motion until 2023 in this renewed motion for summary judgment, where the Supreme Court, for the first time, officially denied our cross motion. So in that sense, we would argue that it's preserved. And again, I realize that this is a wacky situation that doesn't come up many times. On that note, I thank the court very much for its time.
Thanks.
Thank you very much. Thank you all.
Patel versus Macy's. You may proceed.
Good afternoon. My name is Stuart Carlin. I'm representing the appellant, Mr. Patel, in this case. As the court is aware, this...
Can you bring the mic up so we can hear you a little better? Go ahead.
As the court is aware, we believe that the standard applied in this case is the manifest disregard of the law. Under the Federal Arbitration Act, I believe actually there's no disagreement as to the fact that that's the standard that applies. So if you look at the facts in this case, my client was terminated basically for what just amounts to a biased, irrational fear of someone who has brown skin and is Asian. And
that's a very fact-determined inquiry, though, right? And it relies on credibility, and you know where I'm going here. We're allowed to, the arbitrator has the best evaluation of credibility.
Right, but there's no dispute. It's not like they were arguing. There's no dispute that he was accused of
they had non-discriminatory reasons, counsel. Counsel, let me just interject here. Didn't they have non-discriminatory reasons that they proffered?
I'm sorry?
Didn't the defendants have non-discriminatory reasons for the termination that they proffered? You know,
Yeah,
they did provide that.
Yes, Your Honor. The primary reason was that he was dangerous, could go postal.
No, that's not what they said. They said their justification was not he's going to go postal. Their justification was he was not engaged in meetings, he didn't follow instructions, he was not a good collaborator. That's their race-neutral, ethnic-neutral, you know, reason for the termination.
Right, but when his immediate supervisor and the supervisor's supervisor is taking the position that he is prone to violence and that he could go postal without a shred of evidence other than, I think they referred to body language. There was no threats. He didn't get in anybody's face. He didn't threaten anybody. That basically set in motion under the cat's paw theory of a termination. I mean, it's like, I'm not a criminal lawyer, it's almost like fruit of a poisonous tree. You can't make those kind of allegations from without completely causing him to be terminated as a practical matter. If you look at, his immediate supervisor and the supervisor saying the same thing without any evidence whatsoever.
But prior to his protected activity, right, commencing the process,
right.
Isn't it true that his direct supervisors and the supervisor's supervisor were already basically trying to create the necessary paper trail? He was already marked as somebody who probably would not be holding on to his job for too much longer.
Well, I mean...
And this was before his protected activity, which kind of cuts against you.
Well, it does, but it still feeds into the theory that they were doing that because of their because of their stereotypical notions that he would be, he's prone to violence. The other thing that wasn't addressed, I mean, there were a lot of issues that weren't addressed. The spoilage issue was a major issue here where they didn't, where 50, 60 emails subsequent to his complaints of discrimination that were made were missing. The notes to meetings regarding him complaining about discrimination were missing. It's all outlined, well, primarily in the reply brief, what actually was missing. And the standard of spoilage wasn't at all applied in this case because the arbitrator said there wasn't protected activity, even though he was complaining of unequal treatment.
What about the arbitrator saying just that the credibility of respondents' witnesses were so strong? Like believing that there was a non-discriminatory reason for the termination, believing that. That was what the arbitrator believed, that there was a non-discriminatory basis.
Right, but the arbitrator also said that there were many inconsistencies in their testimony. The arbitrator found that there were many inconsistencies in the testimony. It was actually literally dozens of inconsistencies in the testimony. But, you know, we circle around again to, well, first of all, they had an obligation on the spoilage issue. There's a whole bunch of emails that went missing, all subsequent to his complaints of retaliation, even though they preserved apparently some emails before the retaliation. So that was not addressed at all. I mean, it was a manifest disregard of the law on the spoilage issue. You don't even have to show willfulness in New York. You just have to show negligence. And we're talking about Macy's now. We're not talking about like a mom and pop shop here.
Okay. Thank you.
And
we're way out of time already.
Okay.
Okay, we got it though.
All right.
We understand your arguments.
All right. Thank you.
Thank you. People versus LaShawn Martin.
Good afternoon.
Good afternoon.
Catherine Pecor with the Legal Aid Society on behalf of Mr. Martin. I'd like to first address the question of causation, and then I'd like to also turn to the sentencing issue at some point. So we're asking this court to reverse Mr. Martin's conviction as unsupported by legally sufficient evidence and against the weight of the evidence, his manslaughter conviction, because death was not a reasonably foreseeable result of a single unarmed punch.
If you punch somebody in the face such that they fall all the way back, like a tree as described by a witness, hitting the concrete floor such that you fracture your skull, of course you can cause death with a punch.
You can, certainly.
Yes.
But I think that chain of events is what makes this so strange. The way that he fell, without breaking his fall, straight down on the concrete.
He punched a 68-year-old man in the face.
62, I believe. But,
Okay, 62.
But yes. And they're actually both the same kind of stature and weight. There was nothing about, Mr. Babbitt that was sort of an inherent red flag that this would have been more likely to produce death. And I would like to highlight People versus Irby, which this court's decision in 1983. It is really on point, and it is frankly the only single-punch homicide case from any appellate court.
Unfortunately, we see them all too common now, right? We've got people, this is like a thing, where we have young people just going up to people and punching them in the face and knocking them down. This is not the first person who has been injured seriously from this.
Yes,
Also,
I do think that there is increasing news coverage of these events, but I'll just note the man who was just arrested in Manhattan for sucker punching 8 women, and those were charged as hate crimes as well. He was initially charged with misdemeanors, which are bumped up to E-felony because of the hate crime enhancement. He wasn't, charged with attempted assault 1, and I think that the courts and even the DAs and the legislature, as a policy matter, do not believe that a single punch attack should be prosecuted as a homicide.
Regardless of what the result is?
Well,
so it's almost like I have a dog and I get the first bite free?
No.
I mean, that's what you're suggesting.
So I just want to clarify, the result is relevant, but there has to be a nexus between the conduct and the result.
So let's talk about that nexus. What was it that your client was saying just before striking, not just this man, but 3 other people, right?
Yes.
He was talking about the next white person I see, I'm gonna knock him out, I'm gonna take him out.
And he also used the word snuff,
Yeah.
which means to kill.
And I think those all go to the question of intent, but causation is a separate element, and it's a reasonable, objective person standpoint. It's not what he subjectively intended. It's whether a reasonable person would have expected this chain of events to unfold.
So he throws what they call a haymaker punch.
Yeah.
Sucker punch.
And cold cock. In essence, the victim was not expecting to be assaulted at all, and here comes this punch that was delivered with such force that people heard it. They heard it when the fist struck this victim, and then they heard the victim fall, and when his skull hit the sidewalk, sounded, they said, like a skateboard hitting the sidewalk. That must have been done with such force as to possibly cause what he eventually caused.
I just do want to make one clarification, though. The fatal injury was actually from falling over. It was not from the force of the punch, and the medical examiner testified that he could have had the same injuries just from falling over, like fainting. And I think that is an important distinction. Because
while the victim is on the ground, your client says, y'all think I'm playing? The next white person that passes me is going to get knocked out.
Yes.
So prior to him doing it, he says it, and after he says it.
That's right, and I think that that goes to the issue of intent, which is a separate element, and I will concede that he said those things. I'd just like to briefly address the sentence because I see I'm running out of time. I was actually struck by how similar this case was to the first case that was argued on the calendar today. We have a man who was clearly having some type of psychotic break. He was, at the time, not being treated for his schizophrenia. And he ended up being sentenced to more than twice as long as the first client whose case was up today. So we're asking this court to reduce his sentence to somewhere in the neighborhood of 15 years, which is consistent with the plea that he was offered just before trial and that he in fact tried belatedly to accept. I think what's really tragic about this case, and it's tragic because Mr. Babbitt died, but what's also tragic is that this was preventable. This didn't have to happen, and none of this would have happened if Mr. Martin had not lost his supportive housing, which had enabled him to thrive for nearly a decade. This was the first instance since he was diagnosed and treated in 2004 that he disengaged from treatment and that he lashed out in violence. He had a marijuana conviction, but other than that, he did incredibly well for nearly a decade, so he's proven that he can excel in the community when he has those resources, and the moment they were taken away from him, this is when he starts to decompensate. And so I think, your honors are well aware that prison and jail settings are sort of anti-therapeutic for people with these types of serious psychotic mental illness. And I think in recognition of that fact, if we want to promote community safety and we want to make sure that Mr. Martin is a productive member of society, then we need to get him back into supportive housing where he's shown he can do well.
Thank you.
May it please the court, Alexander Michaels on behalf of the people. Just quickly on the foreseeability issue, that issue is entirely unpreserved. It was not raised in defense counsel's motion for a trial or a dismissal. And as the court already seems to appreciate, on the merits of the foreseeability issue, this was an eminently foreseeable outcome, especially given defendant's stated intent to knock out the next white person who walked by. Of course, if you knock out somebody who's standing upright over pavement, it is eminently foreseeable that that person will fall over, will not be in a position to break their fall, and will hit their head hard against the ground, exactly as happened here. Unless the court has any questions on any of the
Can
other.
you address the excessive sentence issue that counsel raised?
Yes, Your Honor. So firstly, I should point out that this is a sentence that was imposed after a lengthy trial, and this judge had presided over the trial and also over some of the CPL Article 730 proceedings in this case. So she was intimately familiar with both the trial proceedings and the CPL Article 730 findings in this case. She also had received a submission from the Osborne Association in anticipation of sentencing that detailed defendant's mental health history. So she was very well positioned to take all of these considerations into account, and she expressly did take them into account at sentencing. She discussed them at length in finding that defendant's 25-year sentence would be appropriate. She could have imposed a longer sentence with consecutive sentences on each of the underlying crimes, but she did not. She declined to do so, and she specifically...
Although that would have been overkill. No pun intended, obviously.
Well, the people were requesting consecutive sentences because of the fact that, of course, this is not just one attack; it is 3 different attacks, and so the
Right, it's 3 different attacks. Now I'm gonna be on the other side. It's 3 different attacks by a person who obviously is suffering some mental health issue, right? And we cannot pretend like that is not real.
Absolutely, Your Honor.
Okay.
And the sentencing court very much took that into account and acknowledged that this was real. One thing that the sentencing court pointed out, and I think it's very relevant on appeal as well, is that defendant has had numerous lapses in following his medication regimen, despite the supervision that he has received.
Tell me about that more.
Okay, so I have in my notes, I have 5 different lapses noted. In 2010, he was psychiatrically hospitalized despite being under living in supervisory housing. He was psychiatrically hospitalized, and I believe it was in that instance that he had medication administered over objection. They needed to obtain a court order to administer long-acting medication over his objection. In 2011, there was another psychiatric hospitalization. I'm not sure whether that one also involved administration of medication over objection, but I think there was a reference to that in the Osborne Association papers. Then in 2013, of course, there was a lapse in his medication before his arrest in this case. His caseworkers were trying to find him. There was some level of supervision going on at this time. They were trying to find him. They issued an alert to try to track him down, and unfortunately, they were not able to do so before this happened. And after his incarceration in this case, he was administered medication over his objection. He was restored to competency, and even though he was restored to competency and able to see what had happened when this medication lapse occurred, he he relapsed and failed to follow his medication regimen again, lost competency again, and then was restored to competency after having been administered medication over objection again. And then even after his trial in this case, he still seemed not to appreciate the significance of what he had done, because when asked for the PSR interview what had happened in this case, he downplayed and minimized his guilt by saying that he'd gotten into an argument over chess and he'd hit this one person. Of course, he'd hit 3 different people, and it had nothing to do with chess. So the idea that he is now able to recognize his need for medication and can consistently be relied upon to comply with his medication regimen is really, really speculative. And I think that's one thing that the sentencing court was really getting at in reaching the determination that she did.
Thank you.
Thank you.
Awesome.
Yes, I just want to address 2 important things that the sentencing court got wrong. One, the court accused Mr. Martin of squandering, quote, an abundance of resources that he had been offered over the years, and accused him of having sort of a pattern of violence whenever he goes off his meds. It's important to note this is the first incident since he began treatment and medication and got into supportive housing that he ever acted out violently. Those 2 lapses, you know, in both cases, it was the system working as it should. Because he had supportive housing, people were monitoring him. They immediately recognized that something was going wrong. They got him into the hospital. He was stabilized, and he voluntarily agreed to keep taking his medication, and that's what should happen in those instances. There was never any claim that he acted violently during those 2 lapses, just that he was behaving erratically and bizarrely, and that his providers were concerned about him.
Are you contesting counsel's statements that on several occasions your client had to be given medication by order?
So in that first hospitalization in 2010, yes. The other instances were when he was incarcerated. And Mr. Martin, that's not really surprising. Mr. Martin has a pattern of decompensation when he's in the jail and prison setting. Every time he's moved back to a therapeutic setting, then he starts to do well. This was the pretrial pattern. He goes to the hospital, they restore competency, they bring him back to jail. All of a sudden, he's not being monitored in the same way. He doesn't have the same level of support. He stops taking the medication. And jail is a violent place. It's reinforcing, unfortunately, the worst of his behaviors. But there is no evidence that he has a pattern of violence in the community. When he has supportive housing and treatment, when he's in the community, he's shown that he can do extremely well. And so that's what we should give him.
Thank you.